Hello, beautiful people, lovers of good things, lovers of goodwill all over the globe. I bring greetings from a grateful heart. Good morning, good afternoon, and good evening, depending on your time zone. Thank you so dearly for always supporting this platform. I really do appreciate. In case you are hearing our voice for the first time, or you are coming across us for the first time, we still remain your one and only Progress News, giving it to you back to back. Remember, in this platform, we react to all videos, and your opinion is highly needed. So sit back, watch this video, and
Still watching Project Justice on Africa Independent Television. We're looking at the Court of Appeal judgment on Nnamdi Kanu delivered last Thursday. Tomorrow would make it 1 week exactly since the judgment was delivered, as frantic efforts are being made by his legal team to secure his release. We ask on Project Justice, is the rule of law on the line? Told you earlier, Kanu's lawyer, Ejiofor, is with me in the studio. Ifeanyi, good to see you. Welcome.
Thank you so much, Mr. Toby.
It's been a hectic one. Back and forth in the court.
Sure. A very hectic one indeed. Judgment is a landmark judgment. Judgment has held the federal government in a vice-like grip, and there's no chance whatsoever of extrication, because it's a watertight judgment indeed. What is now before us to determine to make sure that the federal government comply with order of court. There's a full judgment of the court, of course, away. And that's an irrelevant of court. The judgment, in principle, substance discharge our client, and consequently prohibited federal government from further detaining him and trying him, or even presenting him for trial, or carrying any other further indictment against him. So, on account of the gross violation of his rights, gross violation of international and local laws on extradition proceedings. So, and the court said on account of that, no court in Nigeria will entertain any charge whatsoever against Nnamdi Kanu, and no court in Nigeria will entertain any form of indictment whatsoever against Nnamdi Kanu. These are clear and positive pronouncement by Court of Appeal. It's a superior court of record. So thankfully you mentioned about the reference to the state of execution filed by the nation by ASU for the Court of Appeal Abuja here. What happened there? And the appellate authority has said that you cannot be in contempt of court order and be seeking for imputable remedies for this record. That is not, you can't do that. You must first of all purge yourself of the content of order, content of court, before seeking for imputable remedy for this record. The court directed for his release and condemned his detention whatsoever. What suspected of federal government upon this? As a matter of fact, they were in court, because the Chief State Council was in court on the day the judgment was delivered. So, and by that moment, from that 13th of October till date, Nnamdi Kanu became illegally held in the custody of the DSS. We also proceeded to serve them with letters requesting them to release him unconditionally in line with the order of the court, and also the judgment of the court is and orders made by the court. We will serve on the DSS. We also serve on the AG Federation. Till date, did not comply with this order. So that will tell you the level of belief in the rule of law. Of course, they have no regard for rule of law. Otherwise, Nnamdi Kanu should not be in custody by now. It shall be released since 13th of October. There's no order of court, as I speak to you, sanctioning his further detention in the custody of the DSS. No order of court, because the lower court has been prohibited from issuing further order. We've granted before now, when he was brought in here on 27th of June 2021, he was rushed to court in secret on 29th of June 2021 without reference to us. Then the court made an order. Instead of directing for him to be detained in prison custody, the court said he should be detained in SS custody. We challenged it before the lower court, and the application was dismissed. Today, a court of superior court, an intermediate court, has directed that he should be released. I discharged him. You see, it's important at this point now for us to make a clarification, because some people are being mixing up this child and acquittal, just like in the manner in which the legal attorney of the federation also mixes it up, because in some case I believe then he didn't have opportunity of looking at judgment of the court. So what happened in Nnamdi Kanu's case is more fortifying and strong than mere acquittal and discharge. Of course, I believe you have a fundamental knowledge of law. When someone is acquitted of an offense or indictment, it it does not end there. It's possible the person must have been acquitted on allegations before the court. It doesn't stop the government or whoever is involved or prosecuting him from probably filing a different charge or that borders on a different offenses or indictment against him. But in this case, it's more than that acquittal, because the court says prohibited them. The court prohibited them entirely, its entirety, from commencing any further charge.
Let's even get a clear understanding of acquittal, so for the benefit of our viewers. I checked on the Black's Law Dictionary, and it defines acquittal as the legal and formal certification of the innocence of a person who has been charged with crime.
Sure.
A deliverance or setting free a person from a charge of guilt in a narrow sense. The absolution of a party accused on a trainee before a traverse jury.
Okay.
How does that apply in this case? Because we're talking about a charge was filed. As far as the Court of Appeal is concerned, that charge ought not to have been filed because he was extraordinarily renditioned to Nigeria. So that nullifies the charge in the first place.
Correct. Perfectly correct. But for the benefit of viewers who wants to appreciate the facts difference between acquittal and this charge, as you rightly mentioned, acquitted, referred to as contained in the Black Law Dictionary, then acquittal applies where evidence has been given. When somebody has been brought before the court, evidence has been given by the prosecution. Acquittal can come when a defense has filed a no case submission, challenging probably the evidence before the court on the ground that it was not sufficient to establish the charge against the person. The court can probably, like what happened in the State a few weeks ago.
Yes.
I did a case there. I defended about 6 persons that were brought and charged on frivolous offenses and bogus charge. And at the end of the day, at the end of the prosecution's case, I filed a no case submission, and the court upheld it and consequently discharged and acquitted my clients. That's of them, right? But then at the point that on that day the judgment was read, I'm giving you a live case. The day the judgment was read, the state government filed a different charge that borders on illegal possession of firearms belonging to unlawful society and sundry offenses.
Different from the initial charge.
The one that was charged. So they were discharged and acquitted. So in this case, and I can't raise an objection to the fact that they've been acquitted on different offenses will not enter appearance for the new charge they brought against them. So acquittal is a stage to take place when evidence has been given. Now, if there are cases where someone might have brought a defendant who is brought before the court, probably in the course of the proceeding, the prosecution has given evidence partly through either a witness. It is immaterial that the person hasn't been crossed his mind. The moment the prosecution applied to withdraw the charge, at that point, that proceeding that application will not be granted on based on the person being charged. It will not amount to acquittal. It's not acquittal because evidence has been given. So acquittal applies where evidence has been given, but the evidence given to the evidence given by the prosecution is not sufficient to grant that offense allegedly committed. So, but in this case, the court of appeal is that no charge ought to have been brought in the first place against him because of the manner in which he was abducted in Kenya. An extraordinary rendition to this place, and it's in gross violation of extant international law, conventions, Resolution Act of 284 and Article 12(4) of African Charter of Human and People's Rights, conventions and protocols, which Nigeria is a state party. So it will have done what ordinarily would have been the position is when you notice in Kenya. They were subjected into extradition proceedings. Now, because Kenya and Nigerian government have what they call extradition agreement understanding. It will pass through that process. It's not even total. It's not total. Even when a charge is filed, when that proceeding is commenced, it's not conclusive of the fact that you will be brought to be extradited to Nigeria. It's not conclusive because the court has to be established. The court there during the proceeding will establish whether the evidence adduced against him for the commission of offense is sufficient to satisfy the offense allegedly committed. And when if the court is satisfied that the evidence being presented by the federal government of Nigeria before the Kenya court during the proceedings is so sufficient, they will decide him allowed to go.
Yes.
So it's sufficient.
This is hypothetically, which did not happen in this
It didn't happen.
I remember that you also applied before a Kenyan court to determine whether or not the processes that led to him being brought to Nigeria in the first place extraordinary rendition is just a euphemism for forced abduction by states in a foreign country and taken to an individual taken to another country.
Sure.
Good. So there was a proceeding before the Kenyan court.
Still going on.
Still going on.
Sure.
What's the status of that proceeding?
Now,
and how does that relate to what is before the Nigerian court?
The position is the proceeding before the Kenyan court helped us tremendously. Because in the counter affidavit filed by the Kenyan government in that proceedings, as I speak to you now, in the eyes of the Kenyan law, now they can still in Kenya. But they are stating that they legally admitted him in May this year. And they cannot tell, they can't determine, they can't tell us where he is. But what I'm saying is still in their country. Do you know why? Because he was not subject. It's impossible. It's plausible. Right? That the Kenyan government was a conspirator in this crime against humanity. They're part of it. But you see, when you are doing illegal things, like when you are doing perpetrating illegality and probably busted, when we find a way, we'll start looking for a way we'll come looking for a scared group. But this time around, they find an application, a counter affidavit, stating in their counter affidavit on oath that they legally admitted this person in May 2021. But they don't know about whether he has been taken out of the country. They can't tell us. So which further fortified our allegation that he was extraordinary rendition from Kenya to this place. And also, when this issue was raised before the lower court, we filed an obligation raised as first issue before the lower court, before the high court. It wasn't decided, it wasn't determined. The lower court told his lordship, he turned a blind eye to that issue. It wasn't, and even the federal government never responded to it. You have been able to find a support of the fact that he was abducted and that's
which was part of your grounds of appeal to the
yes, it's the first issue on appeal. First grounds of appeal. So the lower court never make findings of fact in respect to that issue. Neither the federal government responded to that issue, either denying one way or the other, or stating that he was abducted or probably arrested and because they've taken steps to comply with XYZ law. But in this case, the federal government never responded to that issue. And I will file or in our written address. Same happened in court of appeal. Even in court of appeal, they never responded to it. When it was essentially argued in our appellate brief, they never in their responded brief addressed that issue. If you critically look at government of the court of appeal,
yes,
it was also that was never made. They never responded to an indication that admitted committing this crime against humanity. Now, Terrorism Prevention Act of 2022, right? Section 2, sub 3, F, right? It's clear on when a state goes in violation of international laws, which is a state party. In doing that, the state has become by so being committed a terrorism act. So in the eyes of that law, Nnamdi Kanu today is a victim of terrorism. We have action already filed in court on that effect.
All right, let's look at some of the comments made by the Attorney General of the Federation after this judgment was delivered. He said, well, apart from the issues we've talked about, he also said that the decision handed down by the Court of Appeal was on a single issue that borders on rendition. Let it be made clear to the general public that other issues that predate rendition on the basis of which Kanu jumped bail remain valid issues for judicial determination. What do you make of that?
Well, the point is that the position of Attorney General of Federation...
He's talking about, I suppose, the charge that was filed in 2015.
I'm coming. The position of Attorney General of the Federation with respect to the judgment of the Court of Appeal was hasty. Because at the time he was granted this interview, probably issued a statement. He didn't have access to the judgment of the Court of Appeal, and I believe it was a very fundamentally wrong on his part. So the section 15 of Extradition Act E25 LFN 204 is clear. Now, what you are talking about is that once there's a violation of these laws in the manner in which he was arrested, abducted over there, and brought here, it's still the court of total judicial to the charge. Whether the charge offenses relating the recent amendment, don't forget what was brought in here. the charge was amended from 5-count charge to 7-count charge.
And then to 15.
To 15-count charge. 3 consecutive times. And we kept on challenging them at every given point in time. So, and the charge was struck out by a court of appeal. But let me just start the court of appeal on 13th day of October 2022. I will state it clearly for understand. It's only one charge number. Fry court between FRN and Nnamdi Kanu. Right? FHC/CR/ABJ/CR/383/2015. That charge was cleared on that 13th of October 2022. It cannot be resorted again. It has died, natural death. And funeral has been conducted. So the point that there's a total disconnect between him and the law and reality. Because if he has paid attention to the fact that the charge has been struck out, it's total. And the law says you not file a fresh charge against him. Are you with me?
So I'm seeing a kind of a cul-de-sac now for the government, because from the decision of the Court of Appeal means before you proceed with this man, you probably would have to take him back to where you took him from and follow due process to bring him to Nigeria before anything can be commenced criminally against him. But I'll proceed from here to ask, as we sign off, what options are left? Because I mean, Thursday 20th would make it exactly 1 week after the decision was delivered. What options are left for the defense in moving ahead to secure the release of the...
We have articulated far-reaching legal measures to be taken as I speak to you, which I may not be convenient to make it public at this point in time, because strategies are better managed privately than making public, because I also understand that watching the program. So the point is that we are going to ensure total compliance, and there are preparing authorities in this regard. Case of Chukwuemeka against the Lagos State government is clear. When another was obtained by Chukwuemeka, the central government, the state government from demolishing his house. In the matter proceed to Supreme Court, the said no, go and obey that order first. And it happened just the same case of Islameto against the FRN. Because they go and obey that order. So I'm not against them appealing against the right of the court of appeal. They have to appeal. They are concerned right to appeal. But what you are saying and maintaining.
So my quality people, that brings us to the end of this update. Do well to like this video, share and subscribe if you haven't. Subscription is free. Please smash on that subscribe button that says subscribe and turn on the bell icon for more latest updates. See you when I see you. From me to you, from here I said bye.